welcome at the Misuse of Surveillance Technologies during the COVID-19 pandemic panel. My name is Karolina Iwańska. I am a digital rights advisor at the European Center for Not-for-Profit Law, which is an NGO based in The Hague. And this panel is organized by our friends from the International Network of Civil Liberties Organizations. Thank you for joining this panel. People who have not decided to join us might have seen it in the program and thought to themselves, I can't believe that we are still talking about COVID 3 years on. Like, it's time to move on. But while luckily the immediate health dangers of COVID-19 seem to be behind us, in this discussion we'd like to take stock of the emergency surveillance measures that were adopted over the last 3 years in the name of fighting the pandemic. It was a unique emergency in this sense that it was the first global emergency where technology was such a huge part, almost an inseparable part of the response. We have seen a rapid scaling, an unprecedented scaling up of governments' use of technologies to enable widespread surveillance. And these technologies included, of course, much discussed contact tracing and quarantine monitoring apps, but they also included drone surveillance, SIM card tracking, electronic wristbands, and even biometric technologies such as facial recognition technologies. And 3 years on, we increasingly hear governments admit that the use of technology was rather hasty and eventually ineffective. Even yesterday at another panel, we heard a representative of the Ministry of Internal Affairs from the Netherlands admitting that contact tracing apps did not do so much as we thought they would while we were building them. And a part of this dubious effectiveness, there is also the question of compliance of these measures with fundamental rights, with other regulations and the rule of law. The dangerous thing about emergency measures is that governments are very eager to adopt them and extend surveillance powers in the name of emergency, but they're not as eager to then remove or get rid of stop those emergency measures. And the most notable example of this tendency is the expansion of government surveillance powers after the 9/11 terrorist attacks in the US, which established a worldwide infrastructure of invasive data collection, still present 20 years later, despite reports of little to no counterterrorism benefit. And we have actually already seen this tendency also with COVID, with the normalization of certain and repurposing of certain emergency measures, and we will hear more about this today. And what we want to do in this panel is to really reflect on the lessons learned from this experience and what needs to happen to avoid these negative impacts or hasty adoption of surveillance or tech-driven surveillance technology without proper assessment of their fundamental rights impacts in the future, since I believe it's only a matter of time when we are going to be faced with another emergency. Actually, we are already kind of facing, the Russian aggression on Ukraine that has been served also as justifying certain surveillance measures, but also, climate crisis, another health emergency is coming, and we better be prepared for this. And joining me today in this reflection are 4 excellent speakers. So if I could ask to put up our online speaker on screen. I'll start with Martin, who unfortunately couldn't join us today in person, but he's joining us online. It's Martin Mavenjina, who's a senior program advisor at the Kenya Human Rights Commission, and he leads the Transformative Justice Program at the organization. Then to my left is Professor Rosamunde van Brakel, who is a criminologist who works as an assistant professor and the chair of surveillance studies at the Vrije Universiteit in Brussels. Then to the left of Rosamunde is Bastien Querrec, who is a lawyer at the French civil society organization La Quadrature du Net. And to the right is Dr. David Reichel, who's a project manager of social research at the Data and Digital Unit at the EU Fundamental Rights Agency. Join me in welcoming our panelists with a round of applause, encouragement. Thank you so much. So I'd like to start with you, David, and ask you to give us a bit of an overview of how fundamental rights impacts of surveillance measures adopted across the EU, and what will be your main reflection as an agency monitoring fundamental rights developments and that we can draw for the future for this experience.
Hello, thank you. So yeah, thank you for the invitation to this panel. It's a really important topic, and I mentioned it at an earlier panel, but the last time I attended CPDP in person was January 2020. So that was when in the news there was some reports about the virus somewhere in China, and I was like dismissively saying, what can happen, come on. So now taking a reflection a few years later, 3 years later to be here, so it was not imaginable actually for us in January 2020 what will happen in the next few weeks. That like the government will order me to stay at home. So that's also important to reflect that it was quite an exceptional situation we had to face in the past years. So the Fundamental Rights Agency, during the pandemic, we reacted by producing so-called COVID-19 bulletins. These were regular reports that we published between April and November 2020, 6 reports where we used our research network in all the member states to collect some information and data related to fundamental rights restrictions and in different situations with different topics, also including contact tracing apps. In parallel, we also had continued our work stream on new technologies. So we worked and we continue to work on facial recognition technology, on artificial intelligence and fundamental rights. And to be honest, at the beginning of the pandemic, like in the first few weeks, I thought, oh, finally the hype around AI is broken and we have other important things to focus on. But that was actually quite wrong because it took only a few months and then like the work on new technologies and AI really picked up again, and we also continued working on that. So on the pandemic in general, from our bulletins, I mean, of course, a lot of important things happened. It was 14 new member states who called a state of emergency based on either constitutional regulations or ordinary laws. And that affected the enjoyment of several fundamental rights, of course. So it was the freedom of movement, the freedom of assembly were restricted, privacy was interfered with, the right to work, the right to conduct a business, they all were limited during the pandemic. Interestingly, it was only very few member states who actually gave notice under Article 15 of the European Convention on Human Rights to the Council of Europe that they will derogate from some of the rights of the Human Rights Convention. And in addition, 13 EU member states adopted exceptional measures without having specific laws in place. And all these actions actually also led to the European Parliament and also the Venice Commission to actually call upon and recall that fundamental rights prevail also when emergency measures are in place, and that any restrictions are obviously conditional upon the principles of necessity, proportionality, and importantly, temporariness. So, of course, they have to have an end time point. What is more, before I come to technology, of course, the pandemic impacted on all of us. Yeah, so I had to work from home and do homeschooling with my children. That was really hard. But we have to remember that still, at least I have to remember, I was in a privileged position and it was really the vulnerable groups in society that suffered most during this time. Especially elderly people, of course, with a much higher death toll, with much more restrictions than they had. Other groups, people of disability, victims of domestic violence, especially women. That was really hard when you ordered to stay at home, and it really increased potentially the violence as well. And then other groups, Roma, LGBTI people, migrants, mainly living in crowded, overcrowded housing. So they suffered really more, and I think that's also really important to keep in mind that in exceptional circumstances, it's the most vulnerable who are also mostly affected. On the technology, of course, also to mention there was some positive impact as well. So it's really great that we can have someone joining online. It's sad that you couldn't make it, but of course we increased some positive impact as well and have more chances to be in contact together because of the increased use of online tools. But of course, there were also challenges. I mean, we looked into contact tracing apps after the first 2 months of the pandemic and took stock of what has happened in the member states. And it was really like rushed, as Karolina said already. And some member states we have to say, like in a positive way, really engaged the data protection authorities, worked with them on the contact tracing apps. Others did not at all. And rarely we found actually member states who really considered fundamental rights also beyond privacy when building their contact tracing apps. if they were useful, we did not do a formal analysis of this after the pandemic. I will hear other speakers who did that, and so I'm curious to hear. We heard that there was probably limited usefulness. But of course, in general, it's important to try what people can do during this emergency situation. But of course, as I said in the beginning, limiting fundamental rights is a delicate aspect. So we also worked on facial recognition technology, and we published a paper on this before the pandemic. And before the pandemic, we mainly thought about national security issues as the main issues that are used by governments to restrict fundamental rights. And of course, lessons learned that health is also an important area on this. But yeah, when we looked into facial recognition technology as it's used or planned to be used by law enforcement, here there are also a lot of discussions. There are also still political discussions on the AI Act and how this will be restricted. But what we recalled in 2019, and I think that's a good ending of this opening talk in this section, is like to keep ourselves reminded like when and how you can limit certain fundamental rights for specific purposes. So it's outlined in the Charter of Fundamental Rights in Article 52. That any limitation, most of you know this, but it's always good to repeat, must be provided for by law. It must meet the objectives of general interest or be there for the protection of any other fundamental right. It needs to respect the essence of a right and be proportionate. So what this means in practice, the essence, of course, you can never give up fully fundamental rights. You can limit them to some extent, but you can never give them up fully. And they have to be held up. Then, of course, if that can be kept, you have to establish the necessity, meaning you have to prove that there's no other mean in achieving the same goal that is less intrusive than the one you have at hand. It's a necessity. And the next is then the proportionality measure. And that's a very interesting one because you have to show, or at least prove to some extent that you're sure that the measures you take, that the harms through the interference with your fundamental rights do not outweigh the expected benefit. And I think that's actually on technology it's difficult to know sometimes, but at least we work a lot with data and can actually come up with more of this analysis. But that was done in a very rush, and I think that's one of the lessons learned is that we have those rules outlined, how you can limit certain fundamental rights if it's necessary and proportionate. But we should really work on better processes on how to do this for future emergency situations. Thank you.
Thank you very much, David. That's super useful and a very good bridge to our next speaker. Just as a comment, ECNL, INCLO, and Privacy International joined our forces together with partners from 15 countries around the world to indeed map and monitor how technology-driven surveillance was used during COVID and what were implications for human rights and specifically for civic space and civic freedoms. And two of our speakers today, Bastien and Martin, were part of that report, and the cases from France and Kenya featured there quite prominently. So I now want to turn to Bastien, so at La Quadrature, you were monitoring the developments in France and challenged them before courts. Solutions such as drone surveillance used by the police, and there have been some very interesting developments in this area. And I would like you to expand a little bit on what happened in France and what were the lessons learned and what are we seeing to this day with these measures.
Thank you, Karolina, for the invitation and for this introduction. So, La Quadrature du Net was very active during the pandemic. We knew from experience that states of emergency are a source of abuses, and we knew that this pandemic would probably introduce new types of surveillance. Today, even if the pandemic is behind us, the surveillance measures are still very much in place. The pandemic was one excuse. Today, we also see another accelerator, the Olympic Games in 2024. In the ECNL report that you mentioned, Karolina, the particular issue of surveillance drone was assessed, and very recent events give me an excellent case to illustrate my point, as the pandemic was an accelerator of surveillance. So during the COVID, La Quadrature du Net fought, among the other things, of course, surveillance drones. Before the pandemic, these devices were used occasionally by the police in France. We can find traces in the press going back to 2007. But it's most notably with the pandemic that their use began to be noticed. While the whole France was shut down, the police in Paris began to actively communicate about the use of drones to monitor compliance with the obligation of lockdown. So at La Quadrature du Net, we started to focus our efforts on this topic at that time. We seek for the legal framework of these drones, but we didn't find anything. When the press began to get interested in the topic, we had the confirmation from the police itself that there are no specific legal framework and legal basis for this surveillance. In Paris, for example, the police invoked a decree governing the flight rules for these machines, just a decree that has nothing to do with the image recorded and the data processed, and a very vague article of the French Civil Code that declared the rights of privacy. So the legal standards, of course, were not met, and we started this litigation against the use of drones in Paris a month and a half after the start of the lockdown. And the Conseil d'État, the highest administrative court in France, ruled in May 2020 in our favor. It ruled that these drones were processing data and were lacking of legal framework, so their use was illegal. We raised the issue of non-compliance with the law enforcement directive, which, as you probably know, requires, in the same way that the GDPR, that data processing have a legal basis. And the debate before the court, in this case, were focused on the question of whether these devices were processing personal data or not. The police claim, for example, that they only used their drones in situations where they cannot collect personal data. But the Conseil d'État, relying on the methodology of the objective factor of recital 21 of the LED, stated that, technically speaking, nothing was implemented in those drones in order to prevent the police from using the drones in situations other than those described. In particular, the Conseil d'État highlighted that this drone can fly at a very low altitude and are powered with powerful zoom lenses, so they can collect personal data. During the pandemic, still in the summer of 2020, we found that drones were still being used, this time to monitor demonstrations. So when the lockdown obligation were less strict and demonstrations were allowed again, we found that these drones were still on the ground. So we went back to court and won a second time in December 2020. This time, the police in Paris claimed to be using a blurring tool after capturing the images. The question, once again, was whether these devices that blurs images after collecting them was processing personal data or not. Fortunately, once again, the Conseil d'État ruled in our favor. Blurring is only one operation of a personal data processing, and the image captured and then sent to the blurring system still constitutes multiple operations of personal data processing. After this second ruling, the Conseil d'État went even further because it opened the door to an additional source of illegality, as it pinpointed that the government had not provided sufficient details of how these drones were necessary to the surveillance of demonstration. So while the ruling was legally motivated by the lack of legal basis, it went a step further by opening the door to the recognition of their lack of proportionality. The situation at the end of 2020 was at least clear on one point. Drones are not authorized under the French law, so the government tried to legalize them. With the first law in 2021, a second law in 2022, and the implementing decree for that second law was published barely a month ago, so right after the pandemic. These surveillance drones now today have a legal basis, and in order to fight them, we have to argue that they are disproportionate. Yesterday, sadly, the Conseil d'État issued its preliminary ruling in our case, rejecting the case and declaring that nothing for now are sufficient to ban another time these drones. In all of this, the CNIL, the French DPA, is failing. In 2020, during the pandemic, it followed our actions from afar. When we won our first case, it published a press release on its website stating that it was acknowledging the drone ban, but it was the most visible thing against drones. It's true that at the beginning of 2021, after 7 months, about 7 months after our first victory, the CNIL sanctioned the government for the use of police drones. But the authority had no choice because we had two rulings before the Administrative Supreme Court in France. From a political point of view, however, the CNIL was and is today in favor of these drones. The authority considers that its role is also to help the state to introduce new surveillance programs, not only the drones. At the beginning of 2021, for example, just after its sanctions of the government for the use of drones, the CNIL advised the Senate in France on how to legalize them. The Senate was debating the first law about legalizing drones, and the CNIL explained that it could legalize them by labeling them as an experimentation. So the CNIL suggested that the law could deliberately introduce purposes whose proportionality and relevance were unclear, but in the name of an experimentation. Of course, at La Quadrature du Net, we were furious, not only because the CNIL does violating European law and the LED in the first place, but also because it was exceeding its role by supporting such an initiative. A few days ago, I would have told you about a completely different subject. I would have told you about algorithmic video surveillance, aka the use of AI to analyze CCTV footage to automatically alert the police if a suspicious activity is detected. We have worked hard on this with the help of INCLO and ECNL, to whom I'm of course grateful. And this recent legalization is also the result of a technology that became mainstream thanks to the pandemic. If I had chosen this example, I would also have told you the critical failure of the CNIL and once again about its efforts to legalize this technology. And to finish, there is a common element in these examples, the failure of institutions. It's relevant for the CNIL, but also for the Conseil d'État and the Constitutional Council in France. I must admit that I'm very concerned about the months and years to come, because all the safeguards seems to have disappeared in the pandemic and today. Yet they could be very effective, and the CNIL in particular has abandoned, in our opinion, its historical purpose of limiting the ambitions of surveillance by the state. The CNIL today is supposed to be an independent administrative authority, and on paper it is. I don't question that. Nobody in the CNIL board is accountable to the government, but on the other hand, the way in which the people who compose the board are appointed raises questions. The role of the CNIL of assisting the government raises questions, and its systematic ineffectiveness in preventing the various surveillance programs raises questions. I still want to end on a positive note. I'm not indeed convinced that it's possible to address all these issues. The CNIL, like the Conseil d'État, can be a powerful guardian for freedoms, but there are other considerations today that interfere with all of this and prevent them from protecting human rights. There is still not much left to do. The foundation has been laid. The institutions are there and we desperately need them. What remains is to truly raise the question of their composition, of how their board members are appointed, and the method used by those safeguards.
Thank you very much, Bastien, for explaining that worrying normalization of surveillance and repurposing of surveillance for beyond the pandemic. And I'd like to now turn to Martin to also ask you about whether you've seen similar tendencies in Kenya. What was the situation in your country during the pandemic, and whether you've noticed any cases indeed of the same tendencies of normalization of surveillance, or was there, or can you paint us a slightly more optimistic scenario? Over to you.
Thanks, Karolina. Good afternoon, fellow panelists, participants. I would have loved to join you physically, but thanks to technology, I am able to join you virtually. 2 years before the pandemic, Kenya enacted 2 critical pieces of legislation that we thought would advance the protection of data. The first piece of legislation that was enacted in 2018 was the Computer Misuse and Cybercrimes Act. Now, this piece of legislation back then was enacted, to enhance data protection and, to try to ensure that data is protected. 2 years later, the COVID-19 pandemic was affected Kenyans, just like other people in the world. And what the authorities in Kenya decided to do is they embraced the use of technology in trying to comprehensively deal with the pandemic. Now, unfortunately, at the onset of the pandemic, we did not have a cure. So Kenya, just like other states around the world, thought, technology is the way to go. So with this, the Kenyan government created 2 applications, the Jitenge app and the COVID Trace app. Now, these applications were used broadly, to conduct contact tracing to ensure that those who are affected by the pandemic do not, affect others. But in hindsight, what this implemented to most Kenyans, and specifically human rights defenders, was that the use of these applications created a conducive environment for surveillance. So it normalized surveillance in most public places within Kenya. So the state could surveil on you using these apps, using CCTV cameras, and there was no pushback against the same. So because of this conducive environment, there were 2 provisions within these critical pieces of legislation that were used to actually criminalize or should I say restrict our ability to or the ability of Kenyans to enjoy their freedom of expression online. So what the government did is the government used the provisions within the Computer Misuse and Cybercrimes Act to punish bloggers for publishing any misleading information about the government's preparedness and a response to the COVID-19 pandemic. So anybody who published information about COVID-19 online risked contravening this provision, specifically Section 23 and 24 of the Act that carried criminal sanctions of 2 and 10 years respectively. Very many Kenyans, of course, were subjected to this. Many Kenyans were subjected to suffered the brunt of this specific provision. And I want to give one specific example of one of the prominent human rights defenders in Kenya by the name of Mutemi Kiama. So Mutemi published, during the height of the COVID-19 pandemic, Mutemi Kiama, the Kenyan government had actually sought to borrow money from the International Monetary Fund to sustain its COVID response, and made frustration by many Kenyans that the debt burden and the cost of living had increased. But what he did is he used his social media platform, that is his Twitter handle, to publish an urge that the Kenyan government cannot actually borrow money because there is no way in which these funds will properly be accounted for. So what happened was that once he published this, he was able to, the authorities here were able to track him to his house, arrest him in the wee hours of the night, and press trumped up charges before him, and specifically for contravening these specific provisions. But following various interventions by the Kenya Human Rights Commission and other civil society actors, we were able to convince and urge out in court otherwise that there was no threshold for actually holding him. But that is just a clear-cut example of how the government had actually weaponized surveillance through use of specific legal provisions. The other key concerns for many human rights defenders in Kenya was that there was poor oversight for COVID data collection. So most of the data that was collected by the state lacked oversight. And the other thing I must mention was that this data was kept for the inordinate period of time. So there was no provision on how long the state would keep this data for. There was lack of independence for the data protection authorities. The other key concern was on the use of telecommunication data to track and trace individuals without regard for due process. The other concern that we had raised was surveillance of public spaces using CCTV and biometric technologies. And lastly, more importantly, the lack of transparency and accountability by the state. So no state official was held accountable to date for the misuse of any of this data. But broadly, there were also concerns that the government was tracking mobile phones of citizens subjected to the mandatory 14-day COVID-19 quarantine. In one of the cases that we documented, a citizen under quarantine received a call from our National Intelligence Service warning her that she was walking towards a local market to turn around and go back home. So it was a clear demonstration of how the state had enhanced its surveillance capabilities. The other thing that the pandemic did was that it was extremely difficult for many Kenyans to exercise their other rights, the freedom to freely express yourself, to picket, to demonstrate. It was extremely difficult for even 2 or 3 people to gather and enjoy their constitutional rights that are clearly reflected in a number of international principles and conventions. So in summary, the COVID-19 experience in Kenya created a conducive environment for the state to continue surveillance. What I could say with certainty is that the surveillance measures and practices adopted to contain the COVID-19 pandemic in Kenya, including the coronavirus track and tracing applications, did not comply with the requirements of legality, necessity, and proportionality under international law and national laws guaranteeing the right to privacy, data protection, freedom of expression, and access to information. But on the flip side, some of the lessons that we could draw from the Kenyan experience, which is a similar experience to most of the jurisdictions in Africa, is that one, there is need for us to actually have proper mechanisms of conducting oversight over the use of these technologies. The second lesson to draw is around the aspect of accountability. There is need to hold those who misuse this information to account, because if you look at Kenya and many other jurisdictions around Africa, nobody has been held account for either misusing this technology, and the state seems to continue using this technology after they conduct enhanced surveillance. With that, Karolina, I would like to leave it for that for now, but I'm happy to take any questions from the audience. Thank you.
Thank you very much, Martin, for this overview that doesn't fill me with optimism. We're going to elaborate, to look at the more optimistic, what can we do to prevent that in the questions, hopefully. And then I want to, last but not least, turn to you, Rosamunde, so we heard a lot about the different regulations and litigations that were that civil society engaged in during COVID. And I wanted to ask you more about the societal implications of surveillance. How did that affect our societies? How did those measures affect our societies? And are those effects here to stay with us? And can they be mitigated somehow through legislation? Over to you.
Thank you. Thank you for the invitation to the panel. Just to give some context about my research. So I have been looking at surveillance technologies in the context of law enforcement and security for a long time. Recently, my focus has been on Belgium and how accountability and governance mechanisms work in this area, or not work, I should say. So as my focus was Belgium, I just want to say quickly a bit about Belgium because it's a very similar picture as the previous speakers. What we saw was this intensification of surveillance. You already also mentioned what happened with 9/11 and the war on terror. This is something that we have seen before and lessons were not learned. We have also seen similar things happening in the context of mega events such as the Olympic Games and major football games. We see surveillance infrastructure being implemented and being considered as proportional in the context because it's supposed to be temporary. But then what we see is that we are stuck with this surveillance infrastructure legacy. There's a legacy towards these exceptional events, and this is in combination with more broader trends in surveillance, because apart from these emergency situations, there has been an increase of surveillance, the use of surveillance in our societies as well. So this combined intensification of surveillance is having a huge impact. And what I'm seeing in my research is that the current governance framework, which is very much focused on data protection compliance, is not dealing with the more collective and social harms that these surveillance technologies and the infrastructure in our society are bringing. And I feel that we are failing there as a society to protect society, to protect citizens, and especially protect, as already was mentioned as well, the vulnerable communities in our societies. They have been completely ignored in the legislation. In the context of surveillance, what you see in decades of research is that vulnerable communities are often the first communities that are most under surveillance. It's striking how then the governance and regulatory framework actually is forgetting these communities. So I think I'll conclude by saying that on the basis what on my research and on other research on surveillance is that we need to think about a broader conception of surveillance harm, which includes social harm. It includes thinking about what is this, what is the risk for our society, what is the risk for democracy, but for example, also, what's the impact on the climate of the use of all these surveillance technologies? These are questions that are not being asked by for example, the police oversight bodies, because they have a very narrow focus on data protection compliance. So here I feel there is a need for possibly additional regulation, but especially rethinking accountability measures, policy instruments, how we can think about addressing these broader harms. So I would be very interested to get some insights and feedback about how because I don't have a legal background, so I'm very interested to hear what, from a legal perspective, how because you're asking me, but I find it hard to answer it. So I would be interested to see how we can address these social harms in regulation. Thank you.
Thank you very much, Rosamunde, for that contribution. And before we open the floor to the audience, I wanted to maybe ask a couple of questions to the speakers. The one that comes to mind immediately is that I feel that there is a certain acknowledgement that the use of technology during COVID has not been a success. But the question is and there are certain initiatives also here in the European Union that aim to take stock and learn something from that experience. For instance, in the European Parliament, there is a special COVID committee that is working on a report precisely almost with the same title as our panel, that talks about lessons learned for the future from the pandemic. And actually, the vote on the report with the recommendation will happen, if I'm not mistaken, in about 2 weeks. So we'll see what the Parliament actually recommends to European institutions to do about that and what conclusions there are. But so that would be my more broader question. It not only related to regulation as such, but also in terms of our response as citizens to this sort of to the next emergency. So what would be? So I also agree. So David made a point that. When an emergency comes, it's essential to act fast in order to respond to that emergency. And I think, technology, I also agree that technology can play a role in effective emergency response. But the question is, is it possible even to do that, to respond effectively and fast, but at the same time give enough consideration of the potential impacts on fundamental rights that these tools might have? So I know it's a very difficult question, but I was wondering whether maybe each of the speakers could reflect a little bit on, let's say, in 2 weeks, another global pandemic hits. Are we prepared after 3 years? Has this work been done? Would governments, in your opinion, know how to react in a way that's not repeating the same mistakes? And if not, what would be those lessons that would be important to learn to prevent those risks? And also, apart from regulation, noting this broader trend of normalizing surveillance beyond emergency situations, how can we as society, as researchers, as civil society, as institutions, as regular citizens, how can we oppose this trend? Is it something to be stopped, or has it been, the legacy of the world of terror is just there to stay, and we have to kind of mitigate the damage and kind of try to choose the least evil solution, making sure there are sunset clauses and so on in different tools that are adopted? Or is there something that can still change that narrative and change that course of events? So that would be just two kind of broadly open questions, just inviting your reflections on this. Maybe we can start with David.
Okay, thank you. Big questions, which I cannot answer as such. But of course, one challenge I obviously see, and this we've seen also in our research before the pandemic on technology, is of course this stepwise introduction of things, and this way, like the legacy we heard that someone can build on without appreciating what a change the use of technology makes. For example, when we interviewed law enforcement people on their potential plans for the use of facial recognition technology. One argument given was in an interview, we have all these cameras over there and we can't go through all this video material. However, then you have to think like these cameras were put in place without knowing that there could be something like facial recognition technology. So using this technology is a game changer because it's much more intrusive than just having a camera and someone afterwards having a human going through. So there could, of course, be that something is in place and then something is built on top of it. But this is changing the purpose and the interference with fundamental rights. And then, of course, the fundamental rights assessment needs to start from scratch again. And when you think about the lessons learned or what could we do to prevent such issues, the pandemic coincided with huge technological developments. And actually, again, last CPDP, before the pandemic, I was there. I was also asked on stage, like, is the GDPR enough to regulate new technologies like artificial intelligence? And this question has answered itself anyway in the meantime. It's not enough. And there are processes. So we are now in the middle of working on the regulation of AI and new technologies. And I think this is also a focus we should put on because technology is advancing quite fast. And of course, law lags behind. That's also normal. But so because we have to do the work thoroughly when creating new laws. But in our research on artificial intelligence, for example, we showed several use cases, and it's quite obvious that in most of the cases, the use of AI may easily interfere with the right to data protection and privacy, obviously. And here we have the GDPR. But there's also a big risk for discrimination and discriminatory purposes that it's used. access to an effective remedy. If you use in an intransparent way technology, it's really hard to challenge decisions based on this. And when it comes to surveillance measures, like in the pandemic, of course, freedom of expression is relevant. So the list of fundamental rights that are impacted on by the use of technologies is quite long. And that's also when we usually call for a fundamental rights impact assessment before using this. And these discussions are currently ongoing also at the EU legislation, but also beyond. Like the Council of Europe is working on a treaty on artificial intelligence. And these are the tools that we should all, also as citizens, like what's the societal impact, that's fundamental rights impact. You don't want to have discriminatory tools. You don't want to have your privacy invaded. And these are the tools we should all try to contribute to get those systems right so that they are better regulated also in new situations of crisis. It's just one area of important action. And just one more point I wanted to make when we speak about the pandemic and laws. When it comes to new technologies, we also have a new kit on the block of EU laws. So since last November, we have the Digital Services Act in place. And in our bulletins, we also found some indications that the case of hate speech has increased quite to some extent during the pandemic. That has several reasons, but we also know that the large companies in moderating online content during the pandemic had to rely more on automated detection. So there was also more technology used for online content moderation. And the Digital Services Act has also a lot of provisions that tackles these challenges. And so that's also a way forward to use this law and see how we can address these technological challenges so that we are also in a better position for any next emergency situations.
Thank you very much, Bastien. Any thoughts on how to prevent that in the future or change the dominant narrative on that?
In France, there is a great example of how we can address that with the COVID app in France. The government tried to introduce in the more mandatory way it could its COVID tracing app, and the scientific field immediately responded with scientific papers showing that this kind of tracing may not be as effective as we could believe, and we had a response with scientific arguments against this type of app, also on the sociological field, about the gap between generation, because not everyone have a smartphone and is not able to use these types of app. But still, the government in France kind of forced the parliament to go in this direction. A minister in France told the parliament that if this app is refused by the parliament, the elected members of the parliament would be responsible for the additional death during the pandemic. So it was a very violent argument to force the adoption of this app. And finally, a law was even not needed because this app was not mandatory and only on a voluntary basis. But still, during the debates, all the scientific arguments were put away, and the sentimental strategy was adopted by the government. And I think that it reflects the failure of institutions in France, at least, because we do not have sufficient sufficient safeguards to powerful enough to say stop. Look on what the literature says. Look on the scientific papers. We do not have this. The CNIL, the DPA, didn't want to go in that way. The government was sure that technology could save us all, and it's very sad because we could have a scientific debate, a calm debate, but the government and using its power in the institutions in France try to go another way.
Thank you very much for linking that institutional crisis to tech solutionism. That's an interesting perspective. And I'll turn to Martin now to ask for any recommendations that you might have. So we are obviously here talking a lot because we are in Brussels. We're talking a lot about the EU context and what the European Parliament, for instance, is doing in this regard. Are you aware of your government or regional organizations kind of also learning from that experience? Or if not, what would be your recommendations that they do?
Okay. Thanks, Karolina. Before I answer your question, kindly allow me to respond to two other questions. One, as to whether the use of technology was a success. Well, for Kenya, the use of technology was not a huge success. That is primarily because, one, when you look at the internet connectivity or penetration within Kenya as a country, not very many places in Kenya, or not very many people are actually able to access internet. So that in itself made the use of technology more or less of a knee-jerk reaction. So you would effectively use technology within the urban areas, but in some rural areas or informal areas within Kenya, it would have been extremely difficult for the state or for authorities to effectively use technology. But what instead the use of technology did during COVID is that it normalized surveillance, and it has increased the state's surveillance capabilities. And then secondly, on how CSOs can prevent this from happening, what we've done as civil society organizations in Kenya and in Africa is that we have effectively used our courts of law to institute public interest litigation cases. So we have challenged some of these repressive provisions. The other strategy that we've used is we have and continue to convene and engage policy actors, that is our members of parliament who are the makers of some of these pieces of legislation, and also with policy relevant duty bearers like our Ministry of Interior and Coordination of National Government, in trying to see if they can actually come up with policy recommendations or that can create a conducive environment for the use of some of these applications. But to your last question on, I think what recommendation I can give is there needs to be comprehensive oversight if surveillance technologies are actually to be used by states. They must not only conform to international accepted standards, but also the laws of the land. So if they're in conformity with the Constitution and if they do not limit human rights defenders or citizens from enjoying these rights, then that is where it strikes the balance between the use of technology and also and for the states, to conduct to use these technologies to actually be able to fight future pandemics. Thank you.
Thank you very much, Martin and Rosamunde. Any solutions? Any easy solutions?
I don't think there are easy solutions. I think there are lots of recommendations, but how realistic and feasible they are, I don't know. But I can give some recommendations. So, and again, I think the answer is also dependent on the context. I think the law enforcement context is very different from other contexts. Also, legally speaking, we have the Law Enforcement Directive, which is translated into national legislations. And for example, in Belgium, it has been interpreted in a way that allows the police to do a lot, right? So there I feel a lot of the safeguards are missing. As the things David is mentioning, the proportionality assessment is not happening. It's just not happening. And there's a huge nonchalance about these technologies and also a lack of expertise about these technologies. So what I would recommend is that there need to be mandatory evaluations done of the use of these technologies. This is not being done. These evaluations should be conducted by an independent body that has interdisciplinary experience. It should not be a legal assessment. It should be an interdisciplinary assessment that includes legal issues, social issues, and ethical issues. And there I want to really advocate in general that there is a lack of social scientists involved in policy making, in the whole policy process around regulation. So to give you an example, and also in the oversight body. So in the proposed AI Act, if you look at the article that deals with the supervisory authorities and which expertise is necessary for these supervisory authorities, social scientists are not mentioned. Now, how are you going to assess the use of AI in practice if you do not know, if you have no knowledge of the practice itself? So what we're seeing in law enforcement is the law enforcement practice is already discriminatory. You're not going to solve it by trying to make bias-free technology. So here I feel really we need to involve social science and preferably also practitioners much more and citizens in these processes, and have also more ethical assessments with citizens asking, is this what we want for our society? Is this something we want in our community? It should not just be a decision that is made higher up. It should be made before investing in the technologies. And here I feel that the current framework is not working because it's often already after the investments have been done that these questions arise. So keep it at that.
Thank you very much. And if I may, this was a perfect advertisement for our panel tomorrow, because ECNL at 10:30 at Area 42 Grant is organizing a panel dedicated to stakeholder engagement in designing AI and assessing the impact of AI. So you're all welcome, obviously, to attend. That was a perfect introduction to this. Thank you so much for this contribution. And now is the moment that I would like to open the floor to your questions. There is a microphone over there, so just please, but if you may just go to the microphone so that we can hear you. And if the question is directed to a specific person, please mention it. Go ahead.
Hello, can you hear me? No? Can you hear me now? Yeah. Thank you. So my name is Sarah Roda. I work in an association that represents European doctors. And I have just three more or less comments. One is a question, actually, because of we have discussed about the fundamental rights impact assessment and how important this is.
Sorry, could you go closer?
Yes. Yeah, how important the fundamental rights impact assessment would be. And actually, in the European Parliament, with the AI Act, many members of Parliament have introduced and tabled amendments in this part. And so my question is, because this would be a fundamental right impact assessment to be made by deployers, and deployers meaning users. And so I ask here, what competences would they have to do this kind of activity? Because otherwise it would be avoid assessment when you don't know what you are doing. And bringing this to the health sector, so this could fit, for example, doctors, because they are deploying technologies with AI. How would they be fit to do this kind of assessment? So in paper it looks good, but in practical terms, is this possible? Then another point that we were discussing, also on health, we see that there has been an increasing of health surveillance for epidemiological purposes. And we have seen after COVID and during COVID, a lot of amendments in relation to several regulations have come up. The revision of the ECDC, the European Medicines Agent's mandate also, and serious cross-border health threats regulation. And there they have implemented digital platforms to exchange usually data, including data from electronic health records. Of course, they will have to put in place several safeguards, but indeed electronic health records are mentioned. And then my final point, just for civil society and how to support. Just a practical example. For example, here in Belgium, you have the indexation level, which is something that at the moment, I don't know if for not-for-profit associations, this is becoming quite problematic, because it's about 11.6% of indexation, and with this, many not-for-profits have to lay off their personnel. So this does not help on civil society in this regard. So just to reflect that indexation and economic issues can also have an impact on civil society. Thank you.
Thank you very much. David, would you like to comment on the fundamental rights impact assessment? How you perceive that as a tool of accountability in that context, and how to do it? Is it possible in practical terms?
Thank you. No, I think that's a question that many ask themselves at the moment, and there's like many people engaged in these discussions. So what we found also in our research when talking to developers and users of AI in our 2020 report was that many of them are actually looking into the ongoing regulation and are looking for more guidance, because it's also a bit of a lesson learned from the GDPR, where there are a lot of principles, but it's especially in the context of AI often hard for practitioners to translate this into practice. So here obviously there is a big need for clear and probably also implementing guidance in whatever the final AI Act will look like. That's of course not to anticipate for me. But so apart from this clear implementing guidance, I think what was mentioned before is also relevant, and that's also relevant in view of oversight, is that it sounds like a very obvious point that was made for years, but it's ever more true when it comes to new technologies and fundamental rights, is the question of interdisciplinarity, so that you really have, like usually we call for oversight needs to be well-resourced, and well-resourced does not just mean enough money and enough staff, but also the right expertise. And that's what makes it a bit challenging, because you have legal questions, you have technical questions, and you have social questions. And it's not a natural way for these different disciplines to speak together. But in this very area of assessing the fundamental rights impact of new technologies, it's ever more important, and then real effort needs to be made for people to try talking together, although they are speaking different languages. And I, for example, come very strongly from statistics background, and then when I started reading computer science, it took me a while to understand that it's very often exactly the same topic, but just using different terms. And there is, of course, a way to go, and I think an effort needs to be put in this direction as well.
Would anybody else like to comment?
Yeah, just a small comment about the impact assessments. So from a practical point of view, I'm quite worried, because if you speak to DPOs, especially in small organizations now, they are already overwhelmed and at the moment don't have the expertise that they actually should have, right? So I don't know how we can solve this, especially when there is no funding, not enough funding from governments in this area. I don't know how we're going to solve this, because at the moment what I see in Belgium with so Belgium exceptionally has police oversight body for data protection. It is an official DPA for the police alone, and they are understaffed. They don't have much money. It's a continuing issue, and so now, as far as I understand, they will have to take up also the AI part. And I don't see how, practically speaking, and with the political situation in Belgium at the moment, how this is going to work, because they will not get the funding to do their work properly. So I feel that there need to be more discussions about how can we make these things practically feasible, because I feel often in the regulation it sounds good, in theory it's good, but then when you put it into practice it doesn't work. So I feel that we need much more practitioners involved in these discussions and to see how we can make it work. So that's my...
If I may allow myself just to comment on the AI Act and the Fundamental Rights Impact Assessment, one thing that I think that is necessary is the engagement of actual fundamental rights expertise. So human rights lawyers, essentially, who will be able to translate, indeed, kind of translating between the different languages and able to define what, for instance, freedom of expression means in the context of a specific tool. And that can also be, facilitated by actually speaking to people who are going to be affected by this technology, or civil society organizations who have that expertise, or people with lived experience who have been affected in the past. So that can also, in my opinion, contribute to an assessment that is meaningful and not just a box-ticking exercise. But it goes without saying that it will require effort, and it will require time and resources and effective oversight to actually make it matter. Would you like to, Bastien, Martin, comment on any of those points that were raised?
Just to raise a warning that impact assessments, of course, are required, but shouldn't become the only requirement. In France, for example, we see a huge risk of outsourcing those requirements. We fear that strong impact assessment requirements would be outsourced to the private sector, leading to the creation of a new market. And finally, nobody will read those assessments, and the rest of the requirement on proportionality specifically are met. So I think that it's great to focus on impact assessment, but we also have to make the other requirements also stronger.
Yeah. Make sure that they have teeth, the impact assessments. Martin, any comment on this, or should we go to the next question?
Thanks, Karolina. I just want to agree with the proposals by my fellow panelists, and just to re-emphasize that there is need for there is need to implement effective oversight over the use of surveillance technologies. Over to you.
Thank you very much. We can take some more questions. Go ahead.
Thank you. I'm Sarah Eskens, Vrije Universiteit Amsterdam. I have a question for Bastien. You talked about the situation where they wanted to continue with using surveillance drones only then by calling it an experiment. And you said that the CNIL approved it, but with Quadrature you pushed back against that. So I wanted to ask you, are there conditions under which you would find experiments with these sort of technologies acceptable? Because I think that they can actually help to draw out the societal consequences that Rosamunde was also talking about. So to give a very quick example, in the Netherlands, during the pandemic, we also introduced a Corona tracker app. And soon it turned out that bus drivers were receiving a lot of notifications because, of course, all these people passed by in the bus, and bus drivers had to stay at home all the time. So then employees of bus drivers asked them to just turn off these apps, which actually then led to them receiving no protection at all. And funnily enough, this was something that no one had foreseen. There was a lot of talk about all sorts of data protection implications and other sorts of implications. No one had foreseen that this would be a specific worker group, basically, that would be affected by this technology. And I think this is something that could have been drawn out, basically, in a well set up experiment. So, yeah, are there conditions under which you would accept such experiments with these new type of technologies in pandemic-like situations?
Short answer is no experiment, and respect the GDPR and LED. With the drone, we criticize the CNIL because what it proposed was to introduce in the law purposes where it was a knowledge that nobody knows if it could help in any way to improve security. And what we criticize is that the label experimentation was an excuse to bypass the requirements of the LED and not to apply the law and to make politics. It's our main criticism today against the CNIL. It's that this authority is making politics, and it's not its role. Additionally, in France, it tends to, on the constitutional level, it tends to have a limited control of the law that use the label experimentation. For example, before the pandemic, a financial law introduced a surveillance of social networks with the label of experimentation, and the Constitutional Council ruled that it was okay to introduce this experimentation with limited binding rules, but also asked for another control later when the law would remove the label experimentation. And we also see this kind of light control with the algorithmic video surveillance, where the Constitutional Council asked for a next control later when the law would introduce definitely this technology. So it's very concerning that the label experimentation today is an excuse not to apply the existing law, the existing rules, and we simply could apply them. Also, the CGEU case law is very clear on a lot of topics, and it's a shame for institutions, for the Parliament, or for the DPA that all of this is bypassed thanks to just a label.
Thank you.
Can I also ask you, David, actually, because you mentioned earlier that you are kind of in favor of testing certain solutions to see if they are effective. But my question is, so one of the, as you mentioned, necessity is an important element in human rights test. Can you interfere with human rights? You only can do that when a certain interference is necessary. So essentially, you cannot achieve that result differently. But by the experimentation, I think on its own, means that we don't know actually if that is necessary or not. It's an experimentation. So do you think that these two notions can be somehow married, or does human rights law just exclude that? And you would rather agree with what Bastien is saying on that there's no conditions under which that could even be acceptable?
Hard question. No, I think, of course, whenever you use a certain technology, you need to have some knowledge about how well it works, and that also, like when we spoke to developers, they actually usually focus too much on the technical aspects and never thought in the testing phase about how it may impact on fundamental rights, for example, and like doing a few tests across ethnic groups, for example, if you have a training data set where you can do that. So I think there is a lack of usage of available evidence in making informed decisions of what is proportionate to use in practice. An example is that usually, when you have some predictive software or whatever, people throw around percentages. And one useful exercise in this respect could be translate the percentages into numbers. Like, what does 90% accuracy mean in what context? Because the example on face recognition is usually you get an error rate of 0.0 something, but if you do this on a train station, it still means you flag 1,000 people, innocent people, on an error. And under what circumstances is this acceptable? So that's the number evidence-informed game you have to do when you make the assessment before you use any technologies. So it's evidence-based on the one hand, but then the rights-based approach on the other hand that would provide the solutions.
We can take one last question if anyone has any thoughts or observations. Please go ahead.
Hi, I'm Lisa. I'm a PhD student at the Humboldt University. Thank you very much for your presentation. I just wanted to say that, to comment that from my perspective, is really almost shocking, like the level of hypocrisy of the government when it comes to the narrative that we was being fed with during the pandemic. And I want to give two examples. In France, I was very inspired by the work of somebody called Barbara Stiegler, who was pointing out that the public health system was actually being destroyed, was dying since many years. And that's the reason why it turned into a crisis. Because, of course, if there is no hospital, or if the hospitals are totally full, well, you cannot really deal with that kind of a problem. So then the people had to pay for the lack of responsibility of the government. And then they say, yes, it's a crisis, we have no other possibility, so we have to do this. So I was in Paris during the lockdown, and it was really shocking to see really like the going from a huge amount of liberty to almost nothing. And that they were saying there is no other option. So then I heard about what was done in Taiwan. I don't know if you heard about the Minister of Information in Taiwan during the pandemic. They are called Audrey Tang, and they did this kind of like open source democracy that allowed the people to kind of like interact and comment together on the best solution to choose. And there was no lockdown, the restaurant stayed open and so on. So yes, I think like it's hypocrite to say that because of a crisis situation we need to act in a totalitarian way when we see that it's possible to do it in other ways.
I guess that's where the challenge is, right? How do you know which way is the best? But I hope that experience of the pandemic will teach our policymakers something, and I guess we'll find out with the next emergency. But we'll definitely continue as civil society, as researchers, as institutions contributing to this discussion. And thank you very much for today, and enjoy the coffee break and the rest of the conference.